Welcome to the June 2015 Bond Dickinson Employment Law Podcast. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the employment team here. In this podcast, I'll tell you about some of the major cases that have been reported since my last podcast, dealing with collective redundancy consultation, holiday pay, disciplinary warnings and investigations. Then I'll review the employment bills that were outlined in the recent Queen's speech before looking at some news stories. Lastly, I'll give you some action points to take away with you. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and you can claim for the amount of time you spend listening to it. I'm going to start by looking at the decision of the European Court of Justice in the case of USDAW and another and WW Realisation 1 Limited in liquidation and others, where the ECJ had to consider the meaning of establishment in the Collective Redundancies Directive. The directive requires an employer to undertake collective consultation when it's contemplating making 20 or more employees redundant at one establishment. USDAW argued that all of the former employees of Woolworths and Ethel Austin should have been entitled to protective awards when they were made redundant following the insolvency of the two companies, even if they worked in stores that had fewer than 20 employees. The ECJ decided that establishment is the unit to which employees who are made redundant are assigned. This means that an employer does not have to add together the number of dismissals proposed in all of its establishments in order to decide whether the threshold for collective redundancy consultation has been met. The case will now return to the Court of Appeal to decide whether each store was an establishment. The ECJ's decision is helpful for multi-site employers and will hopefully bring to an end a period of uncertainty regarding the obligation to consult collectively in redundancy exercises or when implementing large-scale changes to terms and conditions of employment. Provided the Court of Appeal decides that each store was an establishment, which it is expected to do, employers will have greater clarity as to when the obligation to consult collectively arises, as they will be able to look at each business unit as a separate establishment and determine the number of employees affected at that particular site, rather than having to consider the number of likely redundancies across their entire business. Are the working time regulations compatible with the EU Working Time Directive? This was the question before the Employment Tribunal in Locke and British Gas Trading Limited. Mr. Locke received around 60% of his total pay in commission. While on holiday, he was not earning commission, which caused a reduction in his pay after his return to work. The ECJ held that this acted as a disincentive for him to take holiday, which was contrary to the Working Time Directive. His holiday pay therefore needed to include an amount to compensate him for the loss of the ability to earn commission while on holiday. The case went back to the tribunal for it to decide if UK law could be interpreted to give effect to this decision. The tribunal decided that it was possible to read words into the working time regulations to give effect to the ECJ's decision. It concluded that the regulations should be interpreted so that, for the 4 weeks annual leave derived from EU law, a worker with normal working hours whose remuneration includes commission or similar payments will be deemed to have remuneration that varies with work done. This suggests that employers will have to look at average pay earned over the 12 weeks leading up to the holiday when calculating holiday pay. The effect of this decision is limited in two respects. First, following the Bear Scotland Limited and Fulton case, a 3-month break between periods of leave will break the chain in a series of deductions and will limit the scope of deductions from wages claims. Secondly, the scope for unlawful deductions claims will be limited from the 1st of July to a maximum of 2 years back pay as a result of a change to the legislation. It has been reported that British Gas is appealing against this judgment, so this may not be the end of the story. In my third case, Shrestha and Genesis Housing Association Limited, the Court of Appeal had to decide how thorough an employer's investigation into misconduct needs to be. Mr. Shrestha was accused of fraudulently overclaiming mileage expenses. He raised various lines of defence at his disciplinary hearing and argued that they had not been properly investigated by his employer. The company carried out some further investigations, then dismissed Mr. Shrestha for gross misconduct. He claimed unfair and wrongful dismissal. The tribunal dismissed his claims, finding that his employer had reached genuine belief in his misconduct based on a reasonable investigation. The EAT dismissed his appeal. The Court of Appeal upheld the decision to dismiss Mr. Shrestha's claims and confirmed that the reasonableness of the employer's investigation should be assessed as a whole. It was not necessary to consider each line of defence raised by the employee and to assess the reasonableness of the employer's investigation in respect of each of them. This is a helpful decision for employers and confirms that an employer is not required to conduct a forensic investigation into every line of defence put forward by an employee in order to show that it has conducted a reasonable investigation. My last case is Way and Spectrum Property Care Limited, where the Court of Appeal looked at whether an employer would be acting reasonably in taking into account a final warning given in bad faith when deciding if the employee's conduct was a sufficient reason for dismissal. Mr. Way was a recruitment manager and was given a final written warning for assisting someone to obtain employment with his employer in breach of the company's fair recruitment procedure. While the final written warning was still live, Mr. Way sent a number of emails in breach of the company's computer usage policy. This would normally have resulted in a final written warning, but the employer took the previous warning into account and dismissed him for misconduct. Mr. Way claimed unfair dismissal and alleged that the earlier warning had been given in bad faith because the manager who disciplined him had sanctioned the recruitment and covered up his own involvement. The tribunal refused to hear evidence on whether the first warning had been issued in bad faith. The EAT concluded that the employment judge should have investigated the warning, but it was valid on its face and had not been challenged earlier by Mr. Way, so it would not have made any difference to his dismissal. The Court of Appeal held that an employer would not be acting reasonably in taking into account a final written warning when deciding whether to dismiss the employee if the warning had been issued in bad faith. The claim was sent back to a different tribunal to decide if Mr. Way had been unfairly dismissed. If an employee alleges that a previous warning was given in bad faith, the disciplinary officer should consider whether there are any grounds for looking into the allegation, particularly if taking the warning into account is likely to result in the employee's dismissal. Next, I'm going to look at the employment bills that were outlined in the Queen's speech. The government intends to renegotiate the UK's relationship with the EU, and the European Union Referendum Bill provides for an in-out referendum on membership of the EU before the end of 2017. The government will bring forward proposals for a British Bill of Rights to replace the Human Rights Act. No detail was given as to when this will be introduced, and it's expected that a consultation exercise will take place first. The Trade Unions Bill will introduce various measures that will reform trade unions and protect essential services from disruption caused by strikes, principally by introducing minimum thresholds for voter turnout and limiting the amount of time for which a strike mandate will remain valid. The Childcare Bill will increase the provision of free childcare for working parents of children aged 3 and 4 to 30 hours a week for 38 weeks of the year. The aim of the Immigration Bill is to reduce demand for skilled migrant workers and crack down on the exploitation of low-skilled workers. It will make it illegal for employers to recruit from abroad without advertising in Britain first. A cap on redundancy payments made to public sector workers to end six-figure payoffs will be introduced by the Enterprise Bill, and ministers will have a duty to report annually on progress made towards meeting the target of 3 million new apprenticeships and achieving full employment under the Full Employment and Welfare Benefits Bill. Lastly, the Extremism Bill will give employers the ability to check whether an individual is an extremist and bar them from working with children. Further details of all of these bills will be announced in due course. And now some employment law news items. A revised ACAS Code of Practice on Disciplinary and Grievance Procedures is now in force. It makes it clear that an employee has an absolute right to request his choice of trade union representative or workplace colleague to accompany him to a disciplinary or grievance meeting. The request to be accompanied has to be reasonable, but this does not apply to the choice of companion. ACAS has also published some guidance on calculating holiday pay, following the EAT decision in Bear Scotland Limited and Fulton and others, that non-guaranteed overtime must be taken into account when calculating statutory holiday pay. The Department for Business Innovation and Skills has published guidance for employers and a code of practice on whistleblowing. The guidance is intended to help employers understand the law and their responsibilities relating to whistleblowing, and encourage them to put a policy in place and arrange training for staff. The Government has announced a review of employment tribunal fees. It will consider how effective the introduction of fees has been at meeting the original objectives while maintaining access to justice. The scope of the review includes the effectiveness of the fee remission scheme. The review is expected to be completed later in the year, and the Government has said it will consult on any proposals for reforms to the fees and remissions scheme. The European Commission has launched a public consultation on equality between men and women in the EU. The purpose is to collect views from a broad range of stakeholders in the context of the preparation of the Commission's policy on gender equality after 2015. The consultation is open until the 21st of July. There are several action points that you should consider as a result of the matters I've covered in this podcast. Do you pay commission? If so, you may need to review how you calculate holiday pay for workers with normal working hours during their 4 weeks EU holiday every year. If during a disciplinary process an employee alleges that a previous warning was given in bad faith, consider whether you need to look into it before taking it into account. Ensure that managers are clear about the rules on employees being accompanied to disciplinary and grievance meetings, and look at the ACAS guidance on calculating holiday pay and the BIS guidance on whistleblowing. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. Thank you for listening.